Good afternoon. It is October 24th, 2014. I wanted to do a really basic video on the requirements of the California Lemon Law. Uh, every time I go onto the internet, I'm always amazed and baffled by all the conflicting information that's out there about the California Lemon Law. And I would just like to do a very basic description of the California Lemon Law. Understand that, as with any body of law, there's ins and outs, there's nuances, there's other things that you need to know, but this is what I might call a very brief overview. And I want to just make 5 points about the California Lemon Law. Number one, what triggers your rights as a consumer under the California Lemon Law is a reasonable number of repair attempts to repair a more significant defect. It doesn't necessarily have to be a catastrophic defect with the car, but if it's something like a slight static in the radio, or some very minor noise which you hear just once in a while, that's not the type of thing that's going to create or make a good lemon law claim. I mean, when you have it has to be a more serious problem with the car, the mechanical functioning of the car, something about the comfort or reliability features of the car, and you give the dealership or the manufacturer a reasonable number of repair attempts. Now, what is a reasonable number of repair attempts? It's kind of like a sliding scale. If you have a really serious problem with the car, brakes that fail, probably 1 or 2 repair attempts is all you need, and then you can assert a lemon law claim. If it's a less serious problem, you're going to probably need some more repair attempts to make sure that you've given the manufacturer or the dealer a reasonable number of repair attempts. You see it on the internet that you need 4 repair attempts within the first 18,000 miles, or you need to have 30 days out of service within the first 18,000 miles. Those are legal aspects of the lemon law, of the California Lemon Law, where you may be able to get some additional advantage if you have that in your favor. But ultimately, the standard of the California Lemon Law is a reasonable number of repair attempts within the warranty period. That brings up the second point, within the warranty period. California Lemon Law does not apply to a car sold as is, or a car that is sold without a warranty, or a car that is purchased from a private party. It just doesn't apply. It applies to cars that you buy from dealers or manufacturers, and they have to be bought with a warranty, and the defect and the repair attempts have to come up during the warranty. Obviously, if they come up earlier in the warranty, your case is going to be stronger, and you're probably going to get more money out of it. If it's one of these things where you have a 50,000 mile warranty and the problem doesn't come up until 49,750 miles, that's not going, it's not to say that you cannot have a lemon law claim. You might, but it's going to be harder to assert the lemon law claim at that particular point. So the car has to have a warranty. Doesn't necessarily have to be a manufacturer's warranty. It can be a dealer's warranty, or it could be a certified warranty. But a car has to have a warranty before you can assert your California Lemon Law claim. As I mentioned before, the defect has to be more substantial. You can't have an insignificant or trivial defect. It has to be something that actually affects the use, the value, or the safety of the car, one of the 3. And the legal language is it has to be a substantial impairment. It can't be a minor or a trivial impairment to the vehicle. It has to be a substantial impairment to the use, the value, the safety of the car. The fourth thing to know about the California Lemon Law is that it applies not only to passenger vehicles, but it applies to cars, boats, RVs, other types of things that people buy for recreation, motorcycles. It applies to all those things. Not recently, actually a few years ago, but it also applies to a passenger car, or passenger type car that is bought, that someone uses for business. Normally, let's say 10, 20 years ago, and I've been practicing lemon law for 20 years, you had to prove, to assert a California Lemon Law claim, you had to prove that the vehicle was used for personal, family, or household purposes, not for business use. Nowadays, if you have, for instance, a lot of professionals, accountants, doctors, lawyers, they'll lease or they'll buy a car through their business, but it's the only car that they have, or maybe they have 2 cars registered to their business. If you have up to 5 cars, or less than 5 cars, pardon me, and the vehicle that you're asserting the lemon law claim is less than 10,000 pounds, a gross vehicle weight rating, then you can assert a lemon law claim. So for instance, an accountant, a doctor, a lawyer who leases or purchases a passenger car through their business, they can assert the California Lemon Law. That's been a recent update and a recent change in the law. Finally, and this is important for you to know, and that is that my firm and most firms will take these cases on contingency or substantially contingency basis. The law provides that if you win your case, the other side, meaning the manufacturer or the dealer, will pay your fees. And so normally, the only cases we don't take on contingency are cases we don't think we're going to win. And then we tell people that they have to pay the attorney because we don't think it's a winning case. But if it's a winning case, yeah, we're going to take it on a contingency. And we like to take a good look at our cases to make sure that they're winning cases. We review all of our cases entirely free of charge. If we like your case, we sign it up on a contingency. Anyway, please contact my firm if you have any questions. 888-453-6665. We look forward to answering any questions about the California Lemon Law. Thank you so much. Bye-bye.